And in that are updated information about CEQA. There's your newest adopted rules of procedure in here. There's some handouts that have been updated that are also available on the Planning Department's website about how to process a land use permit, how to process a subdivision map. And in addition, there was a sheet of paper that was titled Planning Commission that specifically addressed the items that the grand jury wanted covered relative to legislative decisions and quasi-judicial decisions and ex parte communication. And actually, I'm going to turn it over to Tim McNulty from County Council to further describe why this was included and what is included on that page exactly.
Madam Chair, I'm Tim McNulty with the County Council's office. Of the suggestions that were made by the grand jury, the one suggestion that I believe was found to be something that would be worthwhile to do was to amend the Planning Commissioner's Handbook with regard to procedural and substantive due process. And so we've made a slight change to that, and that is on this paper that was part of today's agenda. It's just entitled Planning Commission at the top. And the only part that's really changed, I believe, are the discussion about procedural due process. I don't believe we made a change to the ex parte contact provisions because we didn't believe a change was needed there. But I wanted to just use the occasion we didn't do many of the things that were, or we didn't agree that many of the things the grand jury suggested were necessary, but I did think that we ought to try to all just be on the same page with regard to the question of what's required for procedural due process. So if you could bear with me for a minute or two, I'd like to run through that stuff with you. The Constitution requires that when landowners or adjacent landowners, potential applicants or adjacent landowners come forward to the county, to the Planning Commission for a permit, that they be entitled to procedural and substantive due process. And that means there's really three components to that. They're required to have reasonable notice of when the hearing's going to be, and that includes the neighbors as well, because they've got a property interest at stake. They're required to have a reasonable opportunity to be heard, so they need to be able to give testimony about the thing that they're seeking a permit for or the thing that they're opposing a permit being granted for. And they need an impartial decision maker. And the question that the grand jury was really trying to get at was this idea of who's an impartial decision maker and who isn't. There's case law on the subject, including case law from the California Supreme Court. It's perfectly all right for planning commissioners to have opinions about things, including opinions about land use issues, environmental issues. In fact, it's really the way that this whole process works is to have interested people pursuing things that they're interested in. And so that's an essential part of what the court said is allowed. You're allowed to have opinions. And that's okay for elected officials and for appointed officials as well. The thing that you can't have is bias with regard to a particular applicant or a particular project. And so the thing that you need to avoid is expressing those opinions that might lead someone to believe that they're not going to get a fair hearing. And of course, the big problem would be if there's any sort of conclusionary statement made by planning commissioners about an applicant or about a project prior to that application being heard. And I know that that you're all aware of this already, so I won't spend too much time on it, but I just wanted to reinforce that idea. The unbiased decision maker that we're most aware of was a person down in the LA area who was a planning commissioner who wrote for a local homeowners newsletter, and he just happened to write about a project that was on its way to the Planning Commission and reached a conclusion in the newsletter that the project was going to have an effect on wildlife corridors that was going to be a significant impact. And he then sat on the matter, was part of a 3-2 vote to deny the project, and in the subsequent litigation, the court concluded that he really wasn't an unbiased decision maker because of this conclusion that he'd reached in this writing that he had made. And that's really the clearest example of how you could run into trouble. You're allowed to have opinions, you're allowed to have opinions on land use and planning issues, but you have to remain unbiased about particular projects when they're on their way here. The appearance of bias is something that we, try to avoid, but the appearance of bias alone won't prevent you from being an impartial decision maker under the law. My advice is, if you feel like you can't be fair on a particular permit application that's in front of you, then you shouldn't sit on it. And you should avoid doing anything that looks like a conclusion regarding a project that's headed your way, either in writing or in speaking. You should try to avoid that. And with regard to ex parte contacts, I think we've got that pretty well covered, and I think the Commission pretty well understands it. But the idea there is, when someone has a permit before you, all the information that you're using to decide whether or not to grant that or deny it or condition it, all that information needs to be here in this room, in the hearing room, because everyone is entitled to an opportunity to question that information, to try to present opposing information, to support it if they want to. And unless they know what it is that you're using to make your decision, they won't be able to do that. So the applicant, the opponent, neighbors generally are all entitled to know what it is that you know and what it is that you're using to base your decision on. And that's the reason why ex parte contacts need to be revealed, and revealed in a way that explains the information that you gathered during the ex parte contact, whether that's a site visit or an office visit or whatever it was. The bottom line is, when courts review our decisions, and I defend a lot of decisions that the Planning Commission and the board make, they're really looking for fairness. They're looking to make sure that we gave everyone an equal opportunity and that we didn't go into the decision-making process with our minds made up. And I think if you just remember that, you'll be fine. So, that is all.
Thank you, Mr. McNulty. Questions of staff? Seeing no questions, Mr. Caldwell?